Morning, ladies and gentlemen. Welcome to the First District Court of Appeal. We have two cases on our docket, which we'll take in the order that they appear on the docket. After we do the two cases, we will remain and answer any questions that anyone may have about anything that we're at liberty to answer. Obviously, we can't discuss the specific facts of the case, and we will ask the attorneys to also stay in case you have a question from them if they're able to stay. And so with that, we'll call the first case, Ricky GILES versus S&J Entertainment. Counsel.
Good morning. May it please the court. I represent the claimant, Ricky GILES, and I would like to reserve 4 minutes for rebuttal. In this appeal, Mr. GILES challenges the ruling of the trial court below excluding the medical records of the authorized treating provider, Jackson Memorial Hospital, without the court making any case-specific determination that there is any actual procedural prejudice to the employer by admitting these records. The first point I'd like to make is that the excluded records should absolutely be admitted because there is absolutely no prejudice and no surprise to the employer in this case by the admissions of this record. What the judge of compensation claims below does is he applies a per se rule, just like the court in the case of Burgess v. Buckhead Beef disagrees with, that essentially the records were not provided timely to the employer, the attorney for the employer. Now,
is that 440.39?
I mean 440.29 subparent 4.
And so is that where you say that they have to show prejudice before they can come in?
No. The prejudice is only established under the applicable case law, specifically Med Logistics versus Marchines, which cites the Supreme Court case of Finger, the King Pest Control, and it establishes essentially a three-pronged test that or three factors that the court should consider.
Does the 30-day time limit even apply when you're actually taking the deposition of the medical records custodian?
No, it does not. As a matter of fact, it is very clear in 440.29, the last sentence of that section, which is the section that allows the admission 30 days prior of the authorized medical records via motion, states this section does not limit any right of further discovery, including but not limited to depositions. So expressly and explicitly within the statute, it allows for the taking of depositions. And that's what we did in this case. Counsel for the employer at the time of trial agrees that the records can come in either through motion or through a deposition that's properly taken. And that's what happens here.
And the medical records were attached to the deposition, right?
That's correct.
So they wouldn't come in then under the statute?
They wouldn't come in under 440.
And that is a per se rule, 30 days. If you want to admit them that way, you've got to give your opponent 30 days notice. And if you don't give him 30 days notice, he would be safe to assume that you're not going to introduce him.
Not necessarily, and not under the facts of this case, because in this case, the pretrial clearly delineates not only that Jackson Memorial Hospital was an authorized treating provider, but both parties list under documentary evidence medical records, all the authorized treating providers, and under the witness lists, the claimant lists the medical records custodian of Jackson Memorial Hospital. There's no objection at the time of the pretrial. There's no objection at the time of the deposition.
But you know, if I thought that you were going to introduce the record, I mean, in other words, if you gave me the 30-day notice and I had an objection, I would state my objection. But if I didn't think that you were going to introduce something, I mean, I can't imagine that I would have a burden to object to everything that might be irrelevant or inadmissible for some reason in your case, right? I mean, so under the statute, 30 days, I object if I don't like it. If you're not going to introduce them under the statute, then I don't have to worry about it if you haven't given me 30 days notice and you're not moving, correct? So your only way to introduce these would be as an attachment to the deposition.
Correct. Or, right. Or
under the facts of this case.
Well, the judge may still make a determination to allow the records, depending on whether there's any prejudice to the party.
But you don't even need to get to that point in this case, would you?
It's our contention that you do not, correct.
Okay, but I'm a little concerned, about the prejudice prong. I mean, we don't need to get to it in this case, but it's not your position that. Well, it seems to me that if we start letting the records in like this, was emasculating the statute and the 30-day notice requirement.
Well, the 30-day notice requirement only applies to records of authorized screening providers, which is what it is in this case. You know, the first question that the JCC asks at trial on page 4 of the record is whether the pretrial that the parties are traveling under is a pretrial of June 24, 2008. And in fact, both parties agree. Yes, it is. On that pretrial, both parties list Jackson Memorial Hospital. Both parties list all authorized medical records or all medical records of authorized providers. So there's really no surprise here. There's no belief here by either party.
Did you give any 30-day notice on any medical records?
We did not, because we did not introduce them pursuant to the motion of 44029. We introduced them pursuant to deposition as an attachment to the record custodian deposition of Jackson. I mean, we gave notice in the sense that, yes, we list on the pretrial records of all authorized providers. Both parties stipulate Jackson is, and these are the only authorized medical records. These are the only records that were coming into trial. And in fact, the basis for the judge's compensation claims in not allowing the records in really has nothing to do with the fact that the records were not disclosed to the other side. It's a per se timeliness rule that the JCC applies. And we certainly feel that that's improper under the applicable case law, specifically of
Well, under your argument, though, I mean, don't we get back to Judge Wolf's concern that then there's really, you know, instead of having an easy, predictable system that can be self-executing, now we have this, okay, gosh, I gotta look at everything. He said Jackson Memorial, I have to go back in time and go through and make sure there's, you know, versus just a 30-day rule that says, okay, these are the medical records I want to come in, and it is your burden of proof, and if you're not moving the records in to prove your case, opposing counsel isn't going to be overly concerned about that, right? I mean,
certainly, but I think that it's important for the court to recognize that it's a specific legislative intent as enumerated in 440.015 and as indicated also in Burgess of the workers, of the legislature, that workers' compensation cases be decided on the merits, not on the technicality of whether or not, you know, again, we take the record custodian deposition here in an overabundance of caution, because on the pretrial, we both list the records of Jackson Memorial Hospital. There's no surprise to them. They know from day one, they authorized the Jackson Memorial Hospital as testified to at trial by the employer, the principal of the employer, Mr. Vandervorst, on page 77 to 79 of the record, that he knew Jackson Memorial Hospital was authorized. He sent the claimant there. He had the claimant dropped off in a van at Jackson. So again, you know, the proposition that there's any surprise in this case, and this isn't a case where there are all these records. This is a case where this is the one authorized provider's records that were coming in and that were being sought to be introduced. We mutually coordinated the deposition with the employer's counsel. Both parties attended. There was ample opportunity to raise any objection as to timeliness, as to any procedural concerns, prejudice in terms of the records not being introduced 30 days earlier. There is no objection made at the time of the deposition. There is no objection made in the trial memorandum of the employer either.
but if you thought that they weren't admissible because they didn't make the 30-day limit, then he wouldn't need to object, right?
There would be no reason for either party to assume that they were not admissible, because they can always come in as an attack via deposition, and that's exactly what happened here, or the claimant attempted to do. Now,
Okay, address the point that the medical records that you seek to introduce don't actually address the work status of the claimant.
correct. We respectfully disagree with that point. The record is, and I can point out to the court, the records are abundant. This gentleman had a significant injury. This gentleman had a fibula tibia fracture of the right ankle. This isn't someone with an ankle sprain. This is a gentleman that had to be taken to the hospital. Surgery had to be done. Screws and pins were put into his ankle. He was on bed rest. All throughout the records, on page 272, activity chair cast. On page 276 of the record, limited range of motion, right lower extremity, immobilizing device, bivalve cast, extremity weak of the right lower extremity, impaired mobility. On page 284, bed cast activity. On page 288, unable to bear weight, right lower extremity. On page 306, unable to bear weight, right lower extremity. Same thing on page 312. On page 318, these are different reports in the hospital records from different dates, where in all of them it indicates that the rate that the claimant is on non-weight bearing activity On the discharge summary, it indicates the claimant is on non-weight-bearing activity of the right lower extremity. It boggles the mind, I think, that there would be any finding if the judge reviews his records other than the fact that the claimant was on non-weight-bearing activity, could not work. The employer testified at trial that he knew the claimant was on a walker, that the claimant could not do the work that he was hired to do with a walker or with a cast. So I think that...
Well, if that testimony on the record, wouldn't this be duplicative of the testimony from the employer?
It's not, because of the statute. The injury has to be proved via the medical standard. It can't just be established.
Well, if we go down that road, then doesn't everything have to be proven by, I mean, wouldn't we have to go further and say that the doctor would have to testify as to all aspects and we wouldn't be left to infer anything?
I think that if this was a case where, you know, the claimant was claiming a back injury.
But I mean, that's the same statute that says that, though, right? I mean, it says that all medical conditions and the...
What the statute states, and the section you're referring to is 44009 in your coverage, is that major contributing cause has to be demonstrated by medical evidence only. There's no dispute of major contributing cause here. They make a dispute as to causation, that there's no causation to establish based upon the records that the claimant, because, and I think the employer, you know, in this case, for whatever reason, you know, that's something that the employer would have to address. Could have obtained the medical records at any point. If they subpoenaed them from Jackson, I mean, they knew Jackson was authorized, you know, as early as the date of the accident, because they sent the claimant there. So under the statute, I think, you know, only major contributing cause has to be demonstrated by medical evidence. Now, the injury has to be established by a reasonable degree of medical certainty, but, you know, we feel certainly that based on the records, that's something that could be found here, along with the testimony of the witnesses by the trial judge.
We're in your rebuttal time. Thank you.
Yes.
May it please the Court, Mark Edwards on behalf of SJ Entertainment, the appellee, and the employer in this case. I think what the Court has to look at here are a few different factors. One, the claimant is arguing that there's a three-pronged test and that the judge simply ignored the three-pronged test. I don't believe that's accurate. The three-pronged test specifically requires that they show that there's no prejudice, that they didn't intentionally delay in proceeding with discovery.
Why do we even have to get to the three-pronged test if the statute is inapplicable, the 30-day statute?
Well, I don't think the statute is inapplicable. I think the statute does apply. The statute, when it says that it doesn't preclude other discovery, doesn't say that the time limit does not apply.
Okay, but help me here. Why would you be taking the deposition of the medical records custodian if you were not intending to introduce those records into evidence?
I believe they were intending, however, they did not
Okay,
intend.
but hold on a second. This isn't a game of gotcha. You knew they were taking the deposition for the purpose of introducing those medical records, did you not?
Yes, we did.
So you were not shocked, awed, or surprised when they said, we would like to introduce this deposition, were you?
No, we were not.
And you never objected at the time the deposition was taken, did you?
We did not, because it was set so late.
So what is this other than a game of gotcha?
Well, it's not a game of gotcha. The claimant has a burden to present evidence. They waited until less than 30 days before the final hearing on a case that's 3 years old. They say that these were the only records. There were other records. There was an authorized doctor in Texas who treated the injured worker and released him back to work. They listed other doctors when they were saying that there was no one else. If you look at the pretrial, which is part of the record, they listed other medical evidence. They didn't introduce that. And then, with about 15 days left in the case before the trial, after 3 years and after 6 months after the pretrial, is when they first attempted to set discovery. Now, of course, we cooperated and set discovery.
Of course you cooperated, but you did not put them on notice that they were going to have a problem trying to introduce this at the hearing, did you?
Yes, we did. We objected on a couple of different reasons. What is not in the record...
When did you object specifically to the deposition?
We objected at the final hearing, which was less than 10 days after the deposition was taken. I don't think
Tell me what surprise you have. You had these medical records already. It was an authorized provider, right?
We did not have the records. It was an authorized provider originally. The employer thought he had insurance, and when the claimant was first injured, he was sent by the employer to Jackson Memorial Hospital with insurance. The insurance denied coverage. They never sent bills or records to the employer. So yes, we knew that he had treated there, but we did not, with an uninsured employer who were trying to save money in defending him as opposed to running up costs, we did not request the records. They were voluminous, and it was not cost effective when we were not seeking to introduce the records ourselves at the time of the final hearing.
What purpose, I know this is a statutory remedy, but let's talk equity for a second. What purpose, when you had noticed that the records were going to be introduced, it was 10 days before, there was not a lot of surprise in this record, I'm sure. I mean, the employer knew that he was in a wheelchair, non-weight bearing. What purpose does it serve to exclude these records?
Well, because it's prejudicial, and that is part of the test. It's prejudicial to the employer.
Why was it prejudicial?
Because there were subsequent records that we then did not have time to introduce, because we could not get the deposition of the doctor in Texas.
Could you move for continuance?
I don't think...
Could you have moved for a rehearing based on that I want to introduce new records?
Well, I don't think we needed a rehearing because the judge ruled in our favor.
Because nothing came in. But if
Correct.
we lost, could move for a rehearing as well, saying, look, we were not able to get these records because we were surprised. And then we have the case heard on the merits, don't we?
Well, we could do that, but there is testimony of the employer, additionally, that he knew that the claimant was released to work, that he had a job available for the claimant. The claimant at that point left town, made no contact with the employer who had housed him in Texas, given him medical care, paid his benefits the entire time. The claimant simply left, said I didn't contact anyone with the employer. They didn't know that I had a sister in Florida. They didn't know where I was going. And the next contact was 6 months later via a petition for benefits. So clearly, in addition to the fact that the records were not provided timely, I think under the statute, and I think they're prejudicial, the claimant still hasn't met his burden. The claimant's burden in this case to show, one, medical evidence that he's not capable of working, and two, that there's a causal relationship because he can't perform any other work. Once he was released by the second doctor, the employer had a job for him. There's competent substantial evidence to deny benefits based on that. The judge in this case...
Why don't we send it back to the JCC and let him address those issues?
Well, because the judge has already really addressed the issue. He found that the employer was credible, that the claimant was not credible, and any dispute in the evidence between the two should be found in favor of the employer. The employer has already said, I had a job available, the claimant knew that he was released to return to work. So we already know what the judge is going to find. Regarding the medical records having competent substantial evidence, the discharge summary does not indicate in any way what his work restrictions were. Now, whether the employer had knowledge that there were restrictions, whether he paid him, is a different story. It's the claimant's burden to show through medical evidence, not through nurses' notes in the records that the claimant was receiving certain treatment. He did not show in any records upon discharge, which is the relevant time, that the injured worker had any work restrictions. Additionally, once the claimant was returned to work, the employer clearly had a job available for him. The judge found the employer credible. The claimant left, and at that point, there's no medical evidence as to his work status at that time. There would have been, because there was a doctor in Texas who, if we had known that the claimant was going to introduce records, those records would have come in. It would have cured everything. But in this particular instance, I know the court doesn't practice in front of the judges down here, but the attorneys who do have a very difficult time with this firm. They continuously delay. They do not set depositions timely, and it's frequent.
Is any of this in the record in front of us?
Well, you're asking if it's not in the record in front of you, but you're asking the judge to make a decision on whether or not these records are admissible and whether it's a case specific.
If the judge makes a decision based on that, shouldn't you be putting that as factors into evidence so that we as a court can review it? Because you're asking us to determine that this firm does not do right. We have nothing in front of us to say that JCC was right to find that this firm does right. I mean, how do we even accept your representations here today? You're going totally outside the record.
Well, I think there are arguments in the opening statements regarding that. But you're asking the judge to make these determinations. And the judge has knowledge. He has personal knowledge. And I think that's one of the difficulties.
Can you point one case where we can rely, or that we have affirmed the judge when he said, oh, we know what was in his head, and it's not on the record?
No, I don't have those cases.
I suggest you cancel. That's not a very good appellate argument.
As far as this case, though, what we have is a statutory requirement that the claimant didn't meet. We have a burden of proof that the claimant didn't meet. And what the standard of review is, competent substantial evidence, is in the record.
If they had notified you under the statute 30 days ahead of time and said, we're going to bring these records in, they would have brought them in and you couldn't have objected to that. Isn't that correct?
That is correct.
But, so if you had anticipated to prove his case, he needs some medical testimony. We've received absolutely nothing. Then you could have gone out and said, what might they offer, and then prepare a defense.
We would have then filed our timely motion to introduce the records of the doctor from Texas. I believe if you look, there's even part of the record that indicates that the employer had these records, that we didn't introduce them specifically because it wasn't our burden to prove their case. And that is the reason that we did not go forward to introduce those records. We don't want to introduce what they have to introduce. It's not our job to do the claimant's work. And in this particular case, they had no records. They're indicating that there's a stipulation. They objected to our introduction of those records, the Jackson Memorial records, that they say we clearly were going to introduce, and we knew. At the 30-day mark, they hadn't moved to introduce them. Obviously, we were not going to move to introduce them at that point. We have no reason, when it's their burden, and the case law is clear that it's still their burden. It's their burden to move forward with the evidence, and they didn't do that. They didn't introduce one medical record from a doctor. Remember, a nurse is not sufficient. It has to be a healthcare provider listed in the statute. And a nurse is not a healthcare provider listed in the statute who can render a medical opinion. The doctor in this case rendered no medical opinion.
So even if the medical records from Jackson come in, that's your argument that it would be harmless error even if the judge did err, because there's absolutely nothing in there that the judge could have relied on to make the decision that they needed the judge to make in order to prevail.
That is correct. And I don't believe that you can simply go on, well, they knew it was a serious injury. That's not enough. They have to introduce evidence. That's their burden.
Are you saying at this point, though, that there was nothing in those medical records? I'm going to go back and look. Nothing in those medical records that showed that he could not do any have any weight bearing.
There was evidence that there was not weight bearing, but on the discharge summary, which is the relevant record, which is the one signed by the doctor, there is nothing indicating that. Additionally, even if the claimant was not capable of bearing weight, that does not mean he was not capable of performing any work. So then, we have the claimant's burden to show that there's a causal relationship. The judge did not find the claimant to be credible, found that the employer, once again, was credible. There was a job available for him once the employer stopped paying. So all benefits were paid from the date of accident up through the beginning of June, approximately 5 months if you look at the record. And at that point is when the claimant was released to work by the doctor in Texas with specific restrictions.
Okay, I want to make sure I understand your argument, because I went back and looked at the order. You're not saying there is anything in here that says, I believe the employer about him having a job available you're relying on paragraph 1 here that just says, I accept the credibility of the employer over the credibility of the employee.
Correct. That I find the employer credible, and I would accept any difference in the evidence. I'm going to rule based on the employer as opposed to the employee. And the claimant in this case specifically said, I looked for no work. He did not attempt in any way to prove a causal connection. He did not, despite the fact that we have an uninsured employer, paid for medical care, housed him, paid for his benefits, and was doing everything required under the statute, did not make any attempt to allow the employer to continue doing that. He simply left, gave no notice, and made no attempt to find employment. So I think if we're wrapping up, based on competent substantial evidence, even if the records come in, you would still have to affirm the decision of the judge of compensation claims. Thank you.
Thank you.
Counsel, it's on want to do sometimes, is when somebody's walking up to the podium. I have a two-part question. There's two things I would like you to address.
Sure.
Number one, the question of the employer testifying that he had a job available, and the judge making a determination that I accept the testimony of the employer over that of the employee, and whether that makes this harmless error. And the other portion of the question is, I'd like you to address the question about, in those medical records that were admitted, whether a doctor specifically opined that this person could not, would not bear weight on his leg.
Well, to answer the second question, these are hospital records, and the discharge summary does state on page 168, do not bear weight on the right leg. There can be no discharge summary without the approval of the doctor, and that approval of that doctor I can't locate it at the moment, but there is a discharge summary from a physician within the record, within the
Okay,
the
just
last...
your representation fine, we'll look. But
Okay.
there is a discharge summary saying that,
There's a discharge summary, and there's also a discharge instruction from a physician. A patient in the hospital cannot be discharged without an order from a doctor.
And does it include a work status, the discharge summary?
The discharge summary does include non-weight bearing on the right leg.
But does that, what about the job they offer him that they say that?
Well, I think that the court needs to look at the record and the fact that the employer testified that for about a 6-month period following the accident, he provided cash payments to the claimant. So there's a dispute as to when exactly it was and the amount. But for at least 6 months, he knew that the claimant couldn't work. The claimant testified that he did do some work following the accident once a week, driving a car for some auction show here in Auburn, Florida. But that his leg would swell up when he would try to do any kind of work. So I think that, there's no dispute as to that by the employer.
Under your argument, I mean, realistically, aren't we really, if we adopt your argument, then the statutory timelines really start to become, they're rendered kind of meaningless, aren't they?
I don't think so.
I mean, the claimant's attorney can say, well, I'm supposed to do that by 30 days, and I mean, because one of the purposes of the statute is to get benefits to injured claimants as soon as possible, correct?
Correct.
I mean, and everything about that statute is to move these cases as rapidly as they can. They have to go to mediation within a certain period of time. They have to be set for final hearing within a certain period of time. There's reports, there's statistics kept on how fast these cases are getting to final resolution so that injured claimants can get their benefits. And so if we adopt your argument, in essence, this is a de facto continuance because you wait until 10 days before trial to take the depo, there are the records, now all of a sudden opposing counsel has to either say, okay, these come in, or I have to ask for a continuance to get how I'm going to rebut these records. And so then you've in essence bought a continuance without even asking the judge, right? I mean, if we're going to resolve it on the merits, then we have to continue the case.
Right. Well, the case would have to be remanded, yes, but there would be no continuance. Had the records come in, as they should have, and had the judge reviewed the records, there would be no continuance. They say that we did nothing in this case. That's not correct. We took the deposition, we attached the records, we attempted to introduce the records. The judge made no determination as to whether there was prejudice. So therefore, we would just ask for the case to be remanded so that the JCC can make a determination as to whether there is prejudice in admitting that.
So the reason you're asking for is remand and ask the judge to find out if there's any prejudice by letting these records in. And so if in fact they convince the JCC that they would have to go to Texas, get this doc, that would delay the case, that would be prejudicial, at least for delaying the case, or does the judge have no discretion to avoid granting a continuance?
Well, certainly the judge has discretion as to continuance.
Okay, let me make sure I understand your argument, because Judge Hawks asked you whether you're asking for us to remand for the JCC to make a determination of prejudice. Are you asking us to do that, or are you asking us to return this for the judge to consider the case with the medical records included? And one of the reasons I'm asking that, are you waiving the argument about the question of whether there was a waiver here?
On behalf of the employer?
Yeah.
No, we're not waiving that argument. There was a waiver on behalf of the employer. The only objection raised on the...
And your waiver argument, just so I understand, that's based on the fact that they show up at a depot that you schedule late.
And not object.
There's no evidence that the deposition was scheduled late. In fact, it is indicated in the opening arguments that the deposition was set out more than 30 days before trial. It's just set scheduled to take place. There's a distinction between when the deposition is set and when the deposition takes place. The deposition was set 10 days before trial, but it wasn't set the day before. It wasn't set on that date. It was set beforehand.
What would their objection have been at that depot?
A timeliness objection.
Timeliness as to what? You can certainly take the depot.
Right.
There's no objection they can raise to you taking the depot, correct?
Correct. But the only reason these records are excluded by the judge of compensation claims is based on a person's
Because you didn't comply with it. So basically you would put the EC's attorney in the position of sitting there saying, what should the claimant be doing, and then going through the statute and making every objection to the statute.
Well, just as we have to prepare our case, and we did here when we took the deposition, we have to prepare their case as well.
But they're not allowed to assume that you would comply with the statute in the preparation of your case.
Why wouldn't they? Why would they assume that we're going to show up at trial and not present any evidence? I mean, that just doesn't make any sense. Especially when we're traveling under a pretrial where we both listed medical records, we both listed the medical records of authorized providers. We both listed that Jackson's not.
So the 30-day rule would be nothing.
Well, no, the 30-day rule.
Well, the employer carrier is almost always going to know that the claimant received some medical treatment, and he went to different docs, and and so he ought to just assume that all the evidence that you ought to introduce a few days before trial, you might try to put it together.
Of course. I mean, that's what Binger states. Binger states that Binger defines what the prejudice is, and it states, prejudice in this sense refers to the surprising fact of the objecting party and is not dependent on the adverse nature of the testimony. So, regardless of what the medical records say, regardless of what the evidence says, it's whether there was surprising fact or not by the objecting party, and here there was no surprise. They knew all along about these records. There was no objection to the record custodian listed on the pre-trial, no objection on the trial memo, no objection at the time of the deposition. The only objection is hearsay, and that's something that the judge doesn't find. The judge doesn't find there's hearsay. They make a big ado about chain of custody and the cross-examination of the record custodian witness, and there is no finding of that as a compensation claim. It's not until the judge mentions 440-29, 30 days out, that a light bulb goes off to the employer's counsel at the time of the trial and says, oh, that's right, Your Honor. They also weren't timely produced per 440-29.
You're on time, counsel. I'll let you run over. I'm sorry.